Hi, my name is Nurul Irdina Andau, and I am the first presenter.
Hi, I'm Jamila Dikelolon as the second presenter.
Hi, my name is Stephanie Angeline Anasure and I'm the third presenter.
Hi, my name is Jessica Lumit. I'm the fourth presenter.
Hello, my name is Fiorella Sindumbun and I'm the last presenter.
The Companies Act 2016 retains the power, rights, and duties of auditors provided under the Companies Act 1965. The scope of power and duties of an auditor is stated under Section 266 of the Companies Act 2016. For duty to member, or also known as shareholders, Section 266, subsection 1, every auditor of a company shall report to the members on the financial statement and on the company's accounting and other records relating to those financial statement, and if it is a holding company for which consolidated financial statement are prepared, shall also report to the members on the consolidated financial statement. For public company, Section 266, subsection 1, subsection A of Companies Act 2016, auditors are required to attend the annual general meeting in which the financial statements are laid down before the meetings. For private company, Section 266, subsection 1, subsection B, the financial statements are circulated to its member or laid down at the company's meeting of members. Section 266, subsection 2 and subsection 3 of Companies Act 2016, auditors' main duties are stated. There's 5 main duties that I've listed, which is to examine and form an opinion as to whether the financial statement has been drawn up in accordance with the financial reporting standards of Malaysia and the Companies Act 2016. Next is to examine and form an opinion as to whether the financial statements give a true and fair view of the financial positions of the company as of the financial year end and of its financial performance and cash flows of the year end. The third one is to obtain reasonable assurance that the financial statements are free from material misstatement. Other than that, auditors have to report that the accounting and other records and the registers required by the Companies Act to be by the company have been properly kept in accordance with the provision of the Act. Last but not least, to immediately report in writing to the registrar if he or she has reason to believe that an offense involving fraud and dishonesty is being or has been committed against the company by officers or employees of the company. Now, I'm going to talk about auditors' power and duties under the common law. Auditors are agents to shareholders. Auditors are to be appointed by shareholders and to report to them directly and not through the directors. This is to ensure that shareholders receive independent and reliable information respecting the true financial position of the company at the time the audit was concluded. In the case of Teo Peng Pei against One & Co., Teo Peng Pei was submitted that at the extraordinary general meeting, an item of an agenda saw a resolution that member ratify loans and advance made to certain debtors of the company. These debtors, he allegedly, were wholly or substantially companies in which the directors themselves had interests. The plaintiff alleged that the directors of the company had taken advantage of their position and had utilized funds of the company for their own private purpose in breach of their fiduciary duty, which they owed to members of the company. The court held that the auditors had failed to disclose the irregularities in the accounts to the company. Furthermore, the auditors owed a moral duty to disclose the identity of the wrongdoer. For example, the directors to the minority shareholders. This is because the debtors of the company were the directors. This was not disclosed to the shareholders. Other than the case of Teo Peng Pei against One & Co., there is also a case for Real London and General Bank Limited 1895. The company in this case had not made adequate provision for bad debts. The auditor had discovered that the debts were doubtful and had clearly reported the situation to the directors. But when the directors failed to make provisions instead of reporting the fact clearly To the shareholders, he simply made the statement that the value of the asset is dependent upon the realization. It was held that the auditor had failed in his duty to convey information clearly in his report, and he was made liable for certain dividend improperly paid. It was held in this case that an auditor had a duty to convey facts clearly to shareholders. The auditor whose duty it is to convey information to others does not discharge that the duty by simply giving them so much information as is calculated to induce them or some of them to ask for more.
Duty to the company. The auditor owes a contractual duty of care to the company itself. He also has a fiduciary duty to the company to treat any information and trade secret acquired by him in the course of his professional work as confidential. The contract between company and auditors denotes several implied duties such as duty of care to the company, duty to audit company financial affairs and to form an opinion required, duty to audit company's financial records generally, duty to report to members of the company accounts in the annual general meeting, and duty to use reasonable care and skill while conducting audit and making the report. Duty of care and skill. Where an auditor enters into a contract to perform his tasks and as an auditor, he promised to perform it using a degree of reasonable care and skill. The standard which can be expected is the standard of an ordinary reasonable auditor. For instance, Patrick against Public Accountant Board, 2002, the court held that the auditor had committed professional misconduct because he failed to follow a prescribed statement provided in accounting guidelines. From this case, it can be stipulated that in the event there is any abnormalities, an auditor is expected to inspect the details of the transactions and disclose it to the members, as that is what an ordinary auditor would do in discharging their duties. Duty to third parties. An auditor may be liable to third parties. There are circumstances where the court may find the auditor liable to a third person who relied on an audited accounts if the following conditions are fulfilled. First, the loss or damage suffered by the plaintiff was foreseeable. Second, there was an existing relationship of proximity between the auditor and the plaintiff, and it is reasonable to impose on the auditor a duty of care towards the plaintiff. These conditions are also called as capital test. The capital test is a legal test used in English tort law to determine whether a duty of care exists in a particular situation. The test was established by the House of Lords in the case of the Capital Industries plc against Dickman in 1990. The court held that an auditor appointed to audit a company's account owes a duty toward the audited company and its members as a body. If the auditor failed to exercise the standard of care that is expected of another reasonable auditor in the same situations, the company may sue auditor under the tort of negligence. Other than that, this can also be supported by the judgment in Hadley Bryan against Heller and Partners. The case established that it may be possible to make a claim in negligence for pure economic loss where there is a special relationship assuming responsibility between two parties despite them not going in a contract.
Last part for auditor's power and duties under common law. Duty for confidentiality. Auditor may have to protect sensitive financial information, maintain client trust, and comply with legal obligation. But an auditor may disclose confidential information without the company consent for the confidentiality only in the following situation. For the first one is for the purpose of discharging duties to the company. And the second one is in accordance with provision of written law if disclosure is compelled by the process of law or by competent authority. And the last one for following situation is if disclosure is necessary to protect auditors' interests. And it is important to highlight that under the Companies Act 2016, there are no such duty exists because the duties of an auditor are normally a contractual one. Next, rights and privilege of an auditor. auditor of a company has a various in relation to his or her duties. Under Section 266, Subsection 4, an auditor of a company has a right of access at all reasonable time to the accounting and other records, including register of the company, and is entitled to require from any officer of the company and any auditor of a related company such information and explanation as he desire for the purposes of audit. Thus, the auditor may consult all the books, vouchers, and documents whenever he is so likes. This is his statutory right. Next is under Section 266, Subsection 6. The auditor's report shall be attached to or endorsed on the financial statement or consolidated financial statement and shall, if any member so requires, be read before the company in general meeting and shall be open for inspection by any members at any reasonable time. Next, Section 266, Subsection 7. An auditor of a company or his agent authorized by him in writing is entitled to attend any general meeting of the company and to receive all notice of and other communication relating to any general meeting which a member is entitled to receive, and to be heard at any general meeting which he attends on any part of the business of the meeting which concern the auditor in his capacity as auditor. Subsection 8. If an auditor in the course of the performance of his duty as an auditor of a company is satisfied that, Subsection 8, there has been a breach or non-observe of any provision of this Act, and Subsection B, the circumstances are such that in his opinion the matter has not been or will not be adequately dealt with by comment in his report on the financial statement or consolidated financial statement, or by bringing the matter to the notice of the directors of the company, or if the company is a subsidiary of the directors of its holding company, he shall forthwith report to the matter in writing to the registration of company. The last part is under Section 266, Subsection 9. In addition to Subsection 8, if an auditor in the course of the performance of his duties as an auditor of a public company or a company controlled by a public company is one of the opinion that a serious offense involving fraud or dishonesty is being or has been committed against the company or this act by officer of the company, he shall forthwith report to the matter in writing to the registrar of the company.
Section 286, Subsection 3 of Companies Act 2016. This section has mentioned that an auditor are not liable to be sued in any court or be subject to any criminal or disciplinary proceeding for any report under Section 266 by the auditor in good faith and intended performance of any duty imposed on the auditor under this Act. In other words, an appointed auditor are not liable for any defamation or be sued in any court in relation to statement, whether oral or written, or any reports made in course of duty, if such report was done in a good faith. We are going to move to the next topic, which is removal of an auditor at the general meeting and an auditor rights during the process. In Section 276, Subsection 1, the members of company may remove an auditor from office at any time, according to Subsection 8, by ordinary resolution at the general meeting. 276, Subsection 3 of Companies Act 2016, an auditor may not be removed from office before the expiration of his term except by the resolution under this section. In a simple word, an auditor may be removed or terminated from the office before his or her expiry of term, which is an auditor validity is 2 years and is renewable every 2 years. Under Section 276, Subsection 1, the removal must passing the ordinary resolution at the annual general meeting. Next, Section 277, special notice required for resolution to move auditor from office. Subsection 1, special notice required for resolution to removal auditor at the general meeting. Subsection 2, the company shall send a copy of the special notice of such intended resolution to the auditor that proposed to be removed and the registrar. Subsection 3, the auditor may make a representation in writing not exceeding a reasonable length to the company within 7 days from receipt of the special notice and may request that prior to the meeting at which the resolution is to be considered, a copy of the representation to be circulated by the company to every member of the company to whom notice is sent. In a simple explanation, the removal of an auditor requires special notice of resolution that need to be sent to the auditor that proposed to be removed and the registrar. The auditor then may make a written representation within 7 days of receiving the notice. The auditor have right to be heard or may request a copy of the representation to be circulated or read to every member of the company.
Section 278, Subsection 1 of Companies Act 2016 mentioned that if the resolution is passed under Section 276, Subsection 3, the company shall give a notice of that fact to the registrar within 14 days and pass by a majority of votes which is more than 50% members, and people can be appointed as an auditor at any time. According to Section 297, Subsection 1, Subsection 2, and Subsection B, the removal of an auditor by private company shall not be passed as a written resolution before the expiration of his term of office. Section 322, Subsection 1 of Companies Act 2016 has mentioned the special notice is required. The resolution shall not be effective unless notice of the intention that the special notice should be given to the company at least 28 days before the meeting. Based on Section 322, Subsection 3 of Companies Act 2016, the company shall give its member notice of any such resolution in the same manner and at the same time it gives notice of the meeting. Section 322, Subsection 4, Subsection A, and Subsection B of Companies Act 2016 mention it is not practicable to give its member notice under Section 3. The company shall give its member notice at least 14 days before the meeting. It can be given by advertising in one widely circulated newspaper in Malaysia in the national of language, such as Utusan Borneo, Utusan Malaysia, Berita Harian, and widely newspaper in the English language, such as The Star, The Sun, and also in other manner specified in the Constitution. In conclusion, for the removal of an auditor at the annual general meeting, and an auditor right during the process is the removal or termination of an auditor from the office before the expiry of his or her term, which is 2 years and will be renewable every 2 years. The removal of an auditor that required special notice of resolution that need to be sent to the member and the registrar. An auditor has right to be heard or read the copy of the representation then made within 7 days to every members. The special notice should be given to the company at least 28 days before the meeting. It also can be given by the advertising in one circulated newspaper in two types of language, which is national language and English language. For national language, newspaper can by Utusan Borneo, Utusan Malaysia, and Berita Harian. And for the English language, by the Star and the Sun.